Associates Limited.
Mr. Strong.
Thank you, my Lord. As your Lordship will be aware, I appear for Global Water in this appeal. My learned friend, Mrs. Jacqueline Loomy, appears with Miss Meyer for the Government of the Virgin Islands. This appeal concerns a project for a wastewater treatment plant to be built at Parakeeta Bay in Tortola. The Government of the BVI engaged Global Water to build the plant and to operate it for 12 years. That was done by two contracts signed by the parties on the 19th of September 2006, the Design Build Agreement, the DBA, and the Maintenance Operation and Management Agreement, the MOMA, or MOMA, as I sometimes call it. Now, as the government itself put in its written submissions to the Commercial Court, the business transaction which forms the genesis of this matter is the construction and management of a wastewater treatment facility, which, as the government also pointed out, was a single transaction involving the same parties. And for your notes, that's paragraph 26 on page 222 of the record. For reasons which are not known, and probably don't matter, the government failed to carry out various works required of it, and in particular it failed to level and compact the site on which the plant was to be built. So Global Water was unable to build the plant, and the plant never was built for Global Water to operate. Global Water referred to arbitration its claims for the net income it would have received under the MOMA, and it claimed that net income as damages for breach of both an express term of the DBA and of an implied term of the MOMA. The arbitrators recognised that it was a consequence of the government's breach of the DBA that Global lost the profits that it expected to earn from the MOMA. That's paragraph 39 of the reasons. There's never been any suggestion that Global Water would not have built the plant if the government had provided a prepared site, and once the plant was built, Global would have managed it and earned the profits to which it was entitled under the MOMA. In my submission, Global Water is entitled to recover those lost profits as damages for breach of the DBA because the lost profits due under the MOMA, the loss of profits due under the MOMA was the natural consequence of the government not preparing the site. And what is more, it was a consequence which was expected by both parties at the time of contracting, and liability for which was not excluded by the express or implied terms of the DBA. And we say that Global Water is also entitled to recover the same damages for breach of the MOMA because the government's failure to have the site prepared prevented the occurrence of the commencement date. That's the date from which Global Water was to operate and be paid for operating the plant. The MOMA was not an option contract under which the government had a choice whether to employ Global to operate the plant, and the government is not entitled to escape its commitment to Global by preventing the plant being built. In doing so, we say, the government breached an implied term of the MOMA. Now, to identify the contours of the arguments before the board, can I say a brief word about the government's position and draw attention to the fact that the government's written case largely supports the reasoning in the award, which has been rejected by the Commercial Court and by the Court of Appeal, and indeed the government submits that the Court of Appeal was wrong in important respects. The principal point made by the government in relation to the DBA is an argument that it follows from the fact that the parties entered into two contracts that the government didn't assume responsibility in the DBA for losses arising under the MOMA. In essence, the government says that its liability for breach of the DBA is impliedly limited as a result of the MOMA being a separate contract. And the award rests on a similar argument, albeit slightly differently expressed. The government asserts in its written case that the Court of Appeal's reasoning agrees with that in the award, but the government also accepts that this does not seem to have been immediately apparent to the Court of Appeal, and that rather gives the game away. The Court of Appeal's conclusion is that the award's legal analysis was wrong but that its conclusion was correct on the basis that the parties would have expected the government to respond to Global's termination of the DBA by engaging another contractor to build the plant. We say that that's not a finding that's open to the Court of Appeal and in any event is wrong. As regards damages for breach of the MoMA, the award rejected the implied term contended for on the basis that there was no need for it. The government agrees with that reasoning in paragraph 46 of its written case, but the Court of Appeal didn't. The Court of Appeal found that the MoMA does contain an implied term, albeit a slightly different one, but the government submits that the Court of Appeal was wrong about that, paragraph 53 of its written case. Although it's fair to say that the government does also endorse the Court of Appeal's reason for rejecting an implied term requiring the government to provide a prepared site. So that's the contours of the argument. As the board will know, that Global challenges the award on the ground that it contains errors of law on its face. And put shortly, those errors are finding that the damages for breach of the DBA are too remote and the rejection of the implication of a term into the MoMA. Before getting to that, can I quickly dispose of what in my submission is a distraction? The government's written case begins by urging the board to defer to the award on the basis that ADR is to be encouraged. Well, when parties refer a dispute to arbitration, they intend and hope that the dispute should be resolved in accordance with the law. Under the applicable regime, error of law on the face of the award is a well-recognised and long-standing ground of challenge to arbitral awards. And either the award discloses errors of law on its face or it doesn't. It doesn't assist, in my submission, to consider the strengths or otherwise, in principle, of arbitration as a dispute resolution mechanism. Not least because any consideration of arbitration applicable in this case would be premised on the availability of a challenge on the ground of apparent error of law. So I'm not going to say any more about that at this stage. So with that introduction, can I turn to the issues that relate to damages for breach of the DBA? The issue is whether the award was wrong to find that Global's claim for loss of MoMA profits was too remote to be recoverable as damages for breach of the government's obligation in the DBA to deliver a prepared site on which to build the plant. And if I may, I was just going to outline the sequence in which I was intending to deal with this, if it's convenient to the board. First of all, I was going to identify the award's reasons for its conclusion and briefly say why we submit they're wrong in law. Then I'd like to explain what I respectfully submit are the errors made by the Court of Appeal in the judgment appealed against. And finally, I'll pick up some points made in the government's written case, including its submissions on Transfield Shipping and MacArthur, otherwise known as the Achilles, and that will also provide some further reasons why the award is wrong. So turning to the award then, and it might be useful to...
Are you going to take us to the agreements themselves? Because we need to work out what the parties were agreeing in the two transactions, don't we? Which you've called the single transaction, the two agreements.
Yes, I can show them to.
Well, it's just briefly. I would have thought that was logical.
Yes, I mean, you can take it. We will have read the judgments of the case below.
Yes.
Of the courts below, and we all have read the written cases and statement of facts and issues.
Yes, of course.
I think many of us may also have read those agreements, but there will obviously be debate on their terms.
Well, then perhaps I could just take the board through them quickly. The design build agreement is at page 502 of the record. Can I just draw attention, first of all, to a point which may be relevant later. Clause 2 incorporates two items. Global Water's wastewater treatment facility proposal, which was approved by the government's representative. That's not in the record. The detail of it doesn't matter, but the point is that it was incorporated. And secondly, two letters from the manufacturer of the plant, which, when one reads them, indicate that Mr. Peterson, who is the person from Global Water who signs this contract, is the exclusive representative in the BVI of the manufacturer. And both of those items are incorporated into both contracts. The first one isn't otherwise, well, actually neither of them are referred to in the contract at all later. My submission is that this shows that the plant that was to be built is the same as the plant that was to be operated. That's what the parties had in mind. Now, Clause 3 says that the work is to start with the issue of a notice to proceed, and 3.4 says that Global Water's got to finish it within 180 days, and then 3.5 explains the basis of the contractual timetable, effectively.
You say contractual. The following assumptions have been used. 2, the government will provide the prepared site and the survey within 90 days. That's only an assumption.
Yes.
When we get on to the government's covenants in 6, there's no actual time limit for compliance with them.
That's right.
And correct me if I'm wrong, because I wanted to see what the breach was. There was a breach of this contract. The breach was, if I'm right, that there was a notice given by your client of termination, and this provides that if that's not remedied within 30 days, then termination. Is that the breach?
No, my lord, no. The breach is the breach of Clause 6.1. Clause 6.1 provides that the government shall provide the company with a prepared project site suitable for installation of the facility. The government didn't do that.
But what's the time for doing that?
Well, it has to do that. First of all, of course, my lord is right. It doesn't say the government must do this by date X. But the assumption in Clause 3.5 is that it is going to be done on time to enable Global Water to achieve that timescale. It didn't do it, and it hadn't done it for 2 years.
Yes, quite.
Now, on any view, a contract which the parties assume is going to be finished within 180 days cannot allow the government to do not to fulfil that key obligation for 2 years.
I see.
So it's in breach by that stage, and the award accepts that, and that's.
I know it does, but I just wanted to clarify
So that
in my mind.
My lord's right. There was an argument in the arbitration that because there's no date, that couldn't be said that the government was in breach. In my submission, that would just be silly.
You're saying it wasn't implied it's got to be done within a reasonable time, and it wasn't done within a reasonable time.
Yes,
Very well.
and the giving of notice really followed on the alleged breach of an implied term of reasonable time, and there became an obligation to comply with that notice in 30 days.
Exactly, and in fact you can't serve a notice unless there's already been a breach, because you've got to remedy the breach. That's the effect of Clause 15.
Thank you.
And I don't think that's in dispute.
No.
I mean, there is no dispute that the DBA was breached.
Correct.
No.
Correct. Now, that's what happens. Can I also just draw attention to a couple of other points? The definition of treatment plant on page 506 has what appears to be a typo in it. Means all mechanical, electrical and other equipment or installed items located on the site as described in Clause 4.0. That must mean 5.1 of this agreement, and capable of accomplishing the treatment process. We're actually in Clause 4, so it can't mean that. Clause 5.1, the treatment plant shall be a 250,000 US gallon per day facility comprising the following. Now, the details of this don't matter. The important point is that exactly the same appears at Clause 5.2 of the MoMA. So the treatment plant in both contracts is described and defined in the same way. And then 7.1 is the obligations of the company to design and construct the plant. Clause 9 sets out the proposed payments. No point arises in relation. The first clause 9 is 2 clause 9s. The second one on page 511 is a bit more important. When the company's completed the installation of the plant, that's substantial completion, and the government then issues a taking over certificate, transferring ownership to the government. So the government always owned the site. It's just that Global Water had to buy the things that it was going to put on the site, and they transfer to the government at that point. Thereafter, the company shall issue a commencement notice no later than 10 days after receipt of the taking over certificate, indicating the commencement of the management, operation and maintenance phase of the treatment plant. So it's another indication that it's all the same process.
The management, operation and maintenance phase is a reference forward to what MoMA was about once the commencement date of MoMA came about.
Exactly,
Yeah.
exactly. And so
The reference to the management operation phase is where?
it's
Yeah,
in
it's
second
clause
clause 9 on page
The
5.
last 3 lines of clause 9. So there's the contractor indicates substantial completion. The government then has a taking over certificate transferring ownership, and thereafter the company issues the commencement notice, which you say ties in with the MoMA agreement in writing to commence the maintenance operation, so the management, operation and maintenance phase.
Probably doesn't matter, but strictly the government probably owned the site once it was built anyway. They didn't
Yes.
need a taking over certificate. Sorry, they owned the site, they didn't own the plant once it was built, because once you've attached something to the ground,
Yes, as a matter of the law fixtures,
Yes.
it probably was theirs anyway, but this removes any doubt. Whatever is in the plant,
Yes.
fixture or fitting, goes across to the government.
indeed. Then the MoMA begins at page 523. Clause 1 is the company's undertaking to manage a 250,000 US gallons treatment plant, and so on. Clause 2, as I mentioned, incorporates the same things that were incorporated into the other agreement. Clause 3 sets out the agreement shall be for a period of 12 years effective from the commencement date as defined in this agreement, unless the agreement is determined by the party in accordance with Clause 15. And then commencement date is defined at the top of page 525 as meaning the date on which the treatment plant is first capable of processing 250,000 US gallons per day of influent for transfer to the effluent transfer point, such date to be agreed in writing between the government and the company and shall become an integral part of this agreement. So the period for which Global Water is to operate the plant is 12 years from the commencement date. But that does not mean that there's no contract until the commencement date. There is a contract, the term of the operation of which will start once the commencement date occurs. And that's why we say that it's implicit that the government isn't going to stop the commencement date from occurring.
Is the definition of site on 526 of any importance, Mr. Strong?
Well, I'm not aware of there being a diagram annexed here to
I
marked
wonder
A.
about that.
But a friend knows of one.
The government had a job to produce a prepared site, and I just wondered from the definition of site here whether everybody knew from the start where the site was, and the obligation was really to prepare it for you.
It is, I think I can safely say, I can't point to anything in the award which says this, but I think I can safely say that everybody knew where the site was. The proposal documents had drawings of the facility and so on, and everybody knew where it was going to be put.
Yes,
There was never any doubt. Once the construction work started, after the notice to proceed was issued under the DBA, there was never any doubt as to where the thing was going to be built. And indeed, the discussion in the arbitration, the evidence in the arbitration was about not should you have prepared that site or that site? It was, why didn't you remove that rock? It was that sort of...
And there was at some stage surveys, or there were surveys of the site, so there was no dispute as to
Yes,
what
and
we're talking about.
Absolutely, my Lord. That's, my Lord reminded, that's in the award.
But it's not altogether clear that it can be built, is that right?
Well, it's never been suggested that it couldn't be built. It couldn't be built without the site being prepared.
But there was some doubt whether the site could be
No,
prepared.
there's never been any doubt about that.
Okay.
That's never been suggested.
Well, there's no assertion that this was a contract impossible to perform.
That's never been asserted.
Just to be completely clear, the significance of the word designated in the definition of site, was there any formal designation, I don't know, as a matter of planning law or anything like that? Can you help us with that?
I'm afraid I don't know. But it's the same treatment plant. We see that from the definition of treatment plant, which takes one to clause 5.2, and as I've mentioned, clause 5.2, although the line spacing is different, is the same as clause 5.1 in the DBA. Clause 9 on page 532 sets out how much the government is going to pay to the company, $20 for every 1,000 gallons of influent. So it was known from the outset what was going to be paid. And similarly, if one looks at 531, clause 7.10, the government agrees to make a minimum payment for an influent quantity of 75,000 gallons per day. So it's always going to pay for at least 75,000 gallons per day at $20 per 1,000 gallons, even if it doesn't send that much influent through it. Sort of, it's a bit like take or pay, as it were. I should mention clause 8.1 because my learned friend has referred to it in her written case. The government represents that it's the owner of the treatment plant, and it shall at all times during the term of this agreement grant the company access to and egress from the treatment plant, including such real property, buildings and improvements on which the treatment plant is located and which are reasonably necessary for the company to operate and maintain the treatment plant, such that the company may perform its obligations and exercise its rights under this agreement. Now, of course, at the time this contract was entered into, the treatment plant didn't exist. So when it says the government represents that it's the owner of the treatment plant, it's speaking from the moment that from the effective date, effectively when, as we've seen, the transfer of ownership occurs. But what this clause is saying simply is what would have been implicit anyway: we, the government, will let you get onto the treatment plant to operate it. There's nothing exciting about that. I perhaps might just draw attention to the fact that 534, clause 12.3, that there is in fact an express limitation of damages clause in this contract, and there is one in the DBA as well. That's on page 514, but it's not suggested that the limitation of damages clause excludes our claim. So that there is express provision limiting damages, but we're not within the express limitation.
Yes, because it refers back to the indemnification arrangements.
Yes.
Yeah. You don't need to go there.
Don't need to go there.
No one is arguing that consequential loss is excluded in this case.
It's I won't go there. It's a little bit complicated, and I probably don't need to take up the time doing it. So those are the contracts that explain to the government's, the company's obligations and how the two contracts fitted together. Now, come back to the award. The award is in the record at the start, and its consideration of damages for breach of the DBA begins at paragraph 28 on page 11, from where one sees that the arbitrators are proceeding on the familiar Hadley and Baxendale principles of remoteness. Now, the key question in my submission which emerges from had the Baxendale line of authority, is that the question of remoteness turns on what the parties are taken to have known at the time of contracting. And Chitty summarises the position. I've set it out in my written case. A type or kind of loss is not too remote a consequence of a breach of contract if, at the time of contracting and on the assumption that the parties actually foresaw the breach in question, it was within their reasonable contemplation as a not unlikely result of that breach. And as the board will know, not unlikely comes from the Heron 2, where the House of Lords also used the phrases easily foreseeable, a serious possibility, a real danger, to express the degree of probability that a loss must have for it to be recoverable.
But that formulation takes no account of the fact there could be an exclusion clause.
Absolutely, it
So
does.
you've got to read this as qualified by the parties' agreement.
Absolutely, my lady. And as I've shown, my lady, that there is an exclusion, there's an express exclusion clause here, and it doesn't prevent recovery of the losses that Global claims.
Mm-hmm. The express term doesn't.
The express terms don't. And effectively what the government's arguing is there's an implied exclusion.
Mm-hmm. Still an agreed term, is what they say.
I'm
It
sorry,
follows from the format of the agreements.
Yes, but they don't say there's an express term, so it has to be an implied one. Is
The true construction of the two together.
It's hard to...
Anyway,
I probably don't want to get into an argument about beliefs,
but I just wanted to make clear this is only dealing with one aspect of the law, namely the foreseeability.
Yes. Now, but I've got to get over this hurdle in any event. and the arbitrator said I didn't. In the present case, the parties certainly knew at the terms of the MONA when they entered into the DBA. That's clear. And they also knew that performance of the DBA would inevitably result in the occurrence of the commencement date. That's obvious.
Sorry, I
They
didn't
knew-
hear that.
Could you speak up, please?
I'm sorry. They knew that performance of the DBA would inevitably result in occurrence of the commencement date of the MOMA.
Yes.
The arbitrator's view was that the parties would have regarded it as inevitable that the MOMA wouldn't be performed unless the DBA was performed. They say it was manifestly conditional. That's paragraph 17, which I'm sure the board is aware of. Performance of the MOMA was manifestly conditional upon completion of the DBA. It must have been clear as daylight to the parties themselves that the MOMA could only commence and be performed if the DBA was performed. Now, the possibility of the MOMA not commencing if the government didn't prepare the site on which to build the facility was, we submit, without doubt, easily foreseeable. It was a serious possibility and a real danger. So the Heron 2 test is passed, and the loss claimed is not too remote. Now, of course, the award doesn't refer to the Heron 2 at all, and doesn't refer to the discussion about how likely a loss has to be. And in my submission, the arbitrators had no need to consider that. And that's because at the time of contracting, the possibility of loss of MOMA profits if the government didn't perform the DBA was easily passed. So why then did the arbitrators reject the claim? The passage starts at paragraph 29. The key passage starts at paragraph 29 of the award, where they say, in the middle of that paragraph, regard must be had to the fact that the parties had, at the same time they made the DBA, made the MOMA, and were aware of the profits that Global would make. And then in 30, they go on to say, picking it up in the third sentence, the natural consequence of a failure to perform by either party to perform the DBA would be the loss of benefit due to the other under the contract. If Global failed to design, the government would lose the benefit of having the facility. If the government failed to perform its obligations so as to prevent Global from building the facility, Global would lose the payments that were due to it for its work. And then the award goes on to describe what it says were the benefits under the DBA to Global in 31. And in 32, we have the key passage in the middle of 32. The natural and direct consequence of a breach by the government would be the loss by Global of the monies to which Global would be entitled, if any, under the DBA. Since Global wasn't making a claim for monies due under the DBA, there's no damages. Now, what's going on here is the arbitrators are taking the view that because the parties entered into separate contracts, loss relating to one is too remote to be claimed as damages for breach of the other. And in my submission, that's wrong as a matter of law. The natural and direct consequence of a breach of contract is not necessarily confined to monies due under that contract. It doesn't follow from the fact that parties enter into two contracts at the same time that liability for breach of contract A excludes profits that would have been made under contract B. There's no principle of law to that effect, and the arbitrators relied on nothing in the circumstances of this case as leading to their conclusion, other than the mere fact that there were two contracts. Now, we, of course, responded to this point in the arbitration by referring to Victoria Laundry and Newman, and that shows that a party can recover as damages for breach of contract A profits that would have been earned under contract B if contract A had been performed, provided that the parties contemplated the loss of profits as liable to result from the breach of contract A. We submit that the present cases are fortiori Victoria Laundry, because here the two contracts are between the same parties. Now, the arbitrators answered that submission, first of all, in paragraphs 34 to 38 by a reference to the Singapore Court of Appeal's decision in Burgundy Global and Transocean. Time to go through the detail of that, but my submission is, as Mr. Justice Leon found in the Commercial Court, the circumstances of the present case are very different, and my written case explains in paragraph 32 why Burgundy is of no assistance.
Essentially, what you're saying is that in the Burgundy case, the non-payment of the ESCO didn't prevent the performance of the drilling agreement, and Transocean made a commercial decision not to perform the drilling agreement absent the security.
Exactly.
And here you say, by contrast, Global was prevented from performing MoMA because there was no plant.
Yes, exactly.
Yes.
So that then the arbitrators in paragraphs 40 to 43 set out the basis on which they distinguished the Victoria Laundry case, and we say that those points are not a good basis as a matter of law for distinguishing Victoria Laundry. Paragraph 41 is wrong, we say, when it says that Global had no right to use the facility as part of its business to make a profit. That's wrong because the MOMA gave it that right.
Yes, I think, I don't know if you referred to clause 7.2 of the MoMA on MS 530. The government agrees to grant the company full and exclusive use of the site.
Yes, absolutely. And in paragraphs 41 and 42, the arbitrators made the point that the facility would have been owned by the government and not by Global. My submission, that has no legal relevance whatsoever. Wouldn't have made any difference in Victoria Laundry if they'd been leasing the boiler instead of buying it. But can I draw attention to something in paragraph 43? Sorry, in para 42. Starting in the middle of the paragraph, or just after the middle, breach of the DBA prevented the fulfilment of a condition precedent to the performance of a distinct and separate contract. It prevented the MOMA from commencing. We say that that is a finding which can't be challenged.
So there you disagree with the construction placed upon it by Leon J. Leon J. said, look, these arbitrators are saying that that contract never came into existence. But they weren't saying that, to be fair to them, were they, Mr. Strong?
I don't know what they were saying about that. If they were saying that, they were wrong. But
they weren't, were they? They were talking about the commencement of obligation under an existing contract.
You may be right, my lord.
Thank you.
I don't think it matters.
Well, Leon J. hung a lot on that point, didn't he?
He did.
Okay.
And that's clearly the way he read it. My only point is I don't think it's an absurd way to read it, I'm not going to. There's no benefit to me in arguing one way or the other about that.
Okay.
But what you are saying is, as I understand it, is the penultimate sentence of paragraph 42 is it an inferential finding of fact? Is it?
It certainly depends on fact,
Yeah.
and it can't be challenged as a result. Now, so we say that the reasons for distinguishing Victoria Laundry are wrong. That Burgundy is of no use in this case, and that the test of remoteness is passed. So the award, we say, is wrong on its face as a matter of law. Now, can I turn then to the Court of Appeal's judgment? That put forward a different basis for dismissing the claim, and its discussion of remoteness begins at paragraph 85, which is on page 86 of the record. And again, we have the reference to Hadley and Baxendale from Justice of Appeal Mendes, and then he goes on to talk about the Heron 2, which is Kufos and Sarnikov, as the board will know, and he summarises the test that, at the end of paragraph 87 over the page. Now, and you'll see there's a footnote there to the Achilles, so you're certainly aware of it, although he doesn't use any of the reasoning about assumption of responsibility.
That's the second time you have referred to it, but it's not in our authorities.
The Achilles?
It is.
It
It
is.
is in our authorities, right.
Yes, I
It
thought
is,
it is.
yes.
Thank you.
My learned friend relies on it very heavily.
23.
Now, the Court of Appeal went on in paragraph 90 to ask what the parties would have contemplated as not unlikely to follow if Global Water terminated the DBA for the government's breach. And we respectfully submit that that's the wrong question. The question we're concerned with is the secondary obligation to pay damages, which replaces the primary obligation to prepare the site. That's not affected by whether Global terminates the contract. In paragraph 91, Justice of Appeal Mendes makes some observations about what the parties might have considered would happen if Global terminated for breach of the terminated for breach by the government. So he says, at the time, this is the start of paragraph 91, at the time the agreements were concluded, the parties would have appreciated that the design-build agreement did not contain any clause which gave an exclusive right to the respondent to build the treatment plant. Now, in my submission, that's a rather strange point. The design-build agreement gave Global Water the right to build the plant. Plainly, there couldn't be two plants on the same site, so the government couldn't, consistently with the DBA, engage another contractor to build the plant. Doing so would have been a repudiation or a renunciation of the DBA. Then, Justice of Appeal Mendes said, therefore, upon breach and termination of the DBA, the government would have been free to contract with someone else to build the plant. Now, of course, it's true that on termination of the DBA, both parties are released from their primary obligations, and the government comes under a secondary obligation to pay compensation, to put Global Water in the position it would have been in had the primary obligation been performed. And it follows from that that if the government had then engaged another contractor, that wouldn't have been a breach of the DBA because the DBA would have come to an end. But that doesn't really take us very much further forward in my submission. And it's particularly inappropriate to be considering this here because the government didn't engage another contractor. And anyway, the plant couldn't be built by anyone without the site being compacted and properly prepared. The government's obligation is to compensate Global Water for not preparing its primary obligation to prepare the site. If the government had done that, Global Water would have built the site. It's irrelevant what the government might have done thereafter when it didn't do it.
Was the possibility of someone else, another contractor, the legal possibility of another contractor building a site to the Global's design explored at all before the arbitrators?
No.
Because the arbitrators seem to have worked on the basis that the only people who could build the plant which MoMA envisaged were Global or Global's subcontractor.
My Lord, if the government had wanted to raise a point such as the Justice of Appeal Mendes raises, that the government could have engaged somebody else and the parties would have had that in mind at the time, they would have needed to raise that in the arbitration.
Yes,
now,
because there's a factual issue. I mean, who would have the copyright in the design, for example?
For example.
And as far as I understand, none of this was explored. And the Court of Appeal's analysis here is dependent on the assumption that someone could pick up Global's designs and use them.
And that someone could obtain the plant from the manufacturer when Mr. Peterson's the exclusive representative in the BVI.
Yes.
Now, I need to be careful here because I'm challenging the award for an error on its face.
No, but I'm looking at the Court of Appeal's reasoning.
Precisely, my Lord. The Court of Appeal's reasoning depends on a factual assumption, and that factual assumption is not in the award.
That's the point I'm making.
Exactly.
Where is the factual basis for the possibility of another contractor building something which would comply with that which MoMA envisaged?
Precisely, my Lord. And if I can add another point to that, suppose the arbitration had explored this and the arbitrators had just said nothing about it in their award, as they didn't, then it would have been open to the government to say, oh, the arbitrators have misconducted themselves because they have failed to resolve an issue. There is a factual finding which they needed to make, or which the only conclusion that could be reached on the evidence before the arbitrators was that somebody else could have built the plant. The government could have engaged somebody else. And indeed, the government did make a point of that sort in relation to quantum of damages in the commercial court. But it never made a point like that in the commercial court. That wasn't a point that it raised at all. It didn't even raise it in the Court of Appeal until Justice of Appeal Mendes made his point in the Court of Argument. So I respectfully agree with what the Lord Hodge has suggested, that the Court of Appeal's reasoning depends on a factual assumption which it can't make. Can I then just, still in paragraph 91, can I draw attention to this passage? It's, I don't know, about 6 or 7 lines down from the top of the page. The parties would accordingly have had in mind that the termination of the design-build agreement following upon an unremedied breach of the government would not inevitably result in the non-commencement of the management agreement and the consequential loss of profits thereunder. And Justice of Appeal Mendes said that the loss would only happen if the government decided not to build a plant, or if the plant was built and not given to Global. But the point is that remoteness is not about the inevitable result. as the Court of Appeal recognised in its reference to the Heron 2, a loss is recoverable if the parties would have appreciated that it was a serious possibility or a real danger following the event, following the breach. And that includes events with a significantly less than evens chance of occurring. So, in my submission, the correct question was, would the parties have contemplated, if the government failed to prepare the site, that there was a real possibility that Global would suffer a loss of profits that it would otherwise make under the MoMA? If the government failed to prepare the site, it was very likely indeed that Global would suffer losses in respect to the MoMA profits, because without the site being prepared, there was unlikely to be any plant at all. And certainly the MoMA is going to be, the start of it is going to be delayed. In my submission, the arbitrators could only properly find that the damages claimed were too remote if they took the view that the parties would have considered, in the event of the government failing to prepare the site, it was very likely that it would have got someone else to build the plant. Because if they didn't regard that as very likely, they must have regarded the non-construction of the plant as a real possibility, and the test of remoteness has passed. In fact, the award says the opposite. It says that the performance of the DBA was required for the MoMA to start. And there's nothing in the award which supports the Court of Appeal's hypothesis.
Are you going to deal with 93 on page 90, where the Court of Appeal interpret the comment of the arbitrators that at first sight is inconsistent with their conclusion?
Well, my Lord, the point really is the point that Lord Hodge made, that there is nothing in the award which enables the Court of Appeal to make the factual assumption which it makes. And the award proceeds on the basis that the only party that could have built the plant was Global. It proceeds on that factual assumption, whether because there's no contest of that or because they've made that finding doesn't matter. And if you make that factual assumption that only Global can build the plant, my respectful submission, it's not a silly assumption to make given the terms of the contracts and the interlinking between them. It's the same proposal and it's the same description of the plant and all of that. If you make that factual assumption, then what the arbitrators said is correct. It is not to be interpreted as Justice of Appeal Mendes interpreted it. It really is the case that the MoMA can only commence if the DBA is performed.
Yes, paragraph 93 depends on what one treating it simply as a matter of construction rather than having a factual basis.
Yes.
Yeah.
Then they go on to say, if on the other hand, this is the last line of 90, if on the other hand they meant that on a proper construction of the agreement, a breach of the DBA, which resulted in this lawful termination, automatically meant that the management agreement could not commence, they were plainly wrong in law for the reasons already given. Would that, if they were wrong, you say they weren't, if they were wrong, would they be wrong in law in reaching that conclusion?
My Lord, the point that Justice of Appeal Mendes was making, in my submission, was once the design-build agreement has been terminated by Global, as a matter of law, the government is entitled to engage somebody else to build the plant. And I accept that, of course. If the government had done that, brackets, assuming as a factual matter they could, if the government had done that and presented a plant of the requisite capacity satisfying all the terms of the MOMA to Global, then Global's would have had the opportunity to avoid its losses, because it could have said, thank you very much, I'll operate that plant. But none of that happened. And the question is not whether that could have happened. The question is, what did the parties contemplate as likely or not unlikely at the time they entered into the contract? My submission is not simply a question of law. It's a question of law and a question of fact as to whether the MoMA could have commenced. And the arbitrators were, the Court of Appeal's conclusion, insofar as it's a question of law alone, doesn't take you anywhere unless you add in the assumption of fact, which the Court of Appeal can't. So I wasn't going to say anything else about the Court of Appeal's judgment unless I was going to move on to the government's case and turn to what the government's written case says are the two errors in my case. This is at paragraphs 19 and 20 of the government's written case. Paragraph 19 submits that the Hadley and Baxendale line of cases is the wrong test of remoteness. And the government relies on the well-known remarks of Lord Hoffman and others in the Achilles. Now, that's a remarkable submission, since both Mr. Justice Leon and the Court of Appeal applied the Hadley and Baxendale rules on remoteness, and the arbitrators certainly thought they were. So the government is saying that everybody so far has applied the wrong test. And the government has never previously suggested that this is a case where it's relevant to consider the remarks about assumption of responsibility in the Achilles. Now, it's also relevant to note that the passages on which the government relies, and I'll come to them in a minute, operate to limit recoverability of losses which the parties contemplated as not unlikely to result from the breach. So this principal submission of the government only arises on the footing that the arbitrators and the Court of Appeal were wrong, and that Global is right to say that the traditional test of remoteness is satisfied in its claim for breach of the DBA. Now, the Achilles is at tab 23 of the authorities bundle, and can I invite the board to take that up, please? No doubt remember the facts, but let me just summarise them. The owners of a ship had entered into a new charter which was due to start a few days after the current charterers were due to redeliver their ship. And the owners agreed to a final voyage on the old charter in circumstances where it was clear that if there was anything more than a very short delay in the voyage, the follow-on charterers would be entitled to cancel. The inevitable happened. The ship was delivered 9 days late, and the follow-on charter was cancelled because market rates had fallen. The owners were able to negotiate to extend the cancellation date for the new charter, but only on the basis that the charter rate was reduced. So the owners claimed the difference between the rate they achieved on the new charter and the rate they had originally negotiated, and they claimed that over the full period of the new charter. The owners said it was entirely foreseeable that they would enter into a follow-on charter, and entirely foreseeable that market rates would change, and so that their loss was recoverable on Hadley and Baxendale principles. The defendants said, no, we are only liable for the difference between the two rates for the 9 days that the ship was delivered late, because that was the understanding in the market at the time the contract was entered into. Now, at page 67 of the report, at the top of the page, Lord Hoffman identifies the point of principle that he's going to consider. case raises a fundamental point of principle of the law of contractual damages. Is the rule that a party may recover losses which were foreseeable? Not unlikely. An external rule of law imposed on the parties to every contract in default of express provision to the contrary, as Milady says? Or is it a prima facie assumption about what the parties may be taken to have intended, no doubt applicable in the great majority of cases, but capable of rebuttal in cases in which the context, surrounding circumstances, or general understanding in the relevant market shows that a party would not reasonably have been regarded as assuming responsibility for such losses? And then down at paragraph 11, he refers to some academic discussion of the point, and at G, he summarises that, says those articles show that there is a good deal of support in the authorities and academic writings for the proposition that the extent of a party's liability for damages is founded upon the interpretation of the particular contract, not upon the interpretation of any particular language in the contract, but, as in the case of an implied term, upon the interpretation of the contract as a whole, construed in its commercial setting. Of course, this has echoes of the debate about Belize Telecom, and this case, of course, was before Marks and Spencer. And I'm not going to get into a debate about that, but the point is that Lord Hoffman is suggesting there could be an implied term displacing the usual foreseeability rule. In other words, an implied limitation or exclusion of damages. And then at H, he said this: I agree that cases of departure from the ordinary foreseeability rule, based on individual circumstances, will be unusual. But the limitations on the extent of liability in particular types of contract arising out of general expectations in certain markets, such as banking and shipping, are likely to be more common. We say that a deviation from the usual rules is not very likely to occur in the sewage treatment project market is not like banking or shipping. There isn't a general expectation in the market here. Now, paragraph 15, Lord Hoffman, as the board will recall, says that he thinks...
Sorry, just on that, to emphasise it, is the following sentence, the analogy with Liverpool City Council and Derwent, implication of terms by law into particular types of contracts.
Yes. In a way, one can look at Hadley and Baxendale as being the implied limitation on liability that applies as a matter of law in all contracts, but there might be particular circumstances in particular cases where it goes a bit further. There might be a further limitation. But those, Lord Hoffman says, outside particular markets are going to be rather unusual circumstances.
I interrupted you.
No, it's not at all, my lord. Paragraph 15, Lord Hoffman says that the starting place is to decide whether the loss for which compensation is sought is of a kind or type for which the contract breaker ought fairly to be taken to have accepted responsibility. And then at 22, he considers how to determine this. It's not a question of Platonist metaphysics. The distinction must rest upon some principle of law of contract, and in my opinion, the only rational basis for the distinction is that it reflects what would reasonably have been regarded by the contracting party as significant for the purposes of the risk he was undertaking. And then the factors that he identified as relevant on the facts of this case are considered starting at paragraph 23, and I won't go through all of them because some of them are just not relevant for our purposes, but the first one is relevant. And that's that the parties were contracting against the background of market expectations found by the arbitrators. And what the arbitrators had found was that the market expectation was that you wouldn't be liable for this loss over the whole period of the charter. and he goes on at the top of page 71, second line, such a risk would be completely unquantifiable, because although the parties would regard it as likely that the owners would, at some time during the currency of the Charter, enter into a forward fixture, they would have no idea when that would be done or what its length or other terms would be. Now, so the fact that the risk is unquantifiable is key in that case, and it was also key for Lord Hope. Once he's at paragraph 34, he described it as the crucial point that a party cannot be expected to assume responsibility for something he cannot control or quantify. In the present case, that factor points in the opposite direction. The consequences in the present case were entirely within the control of the government, and it could quantify the potential loss to Global because it knew the terms of the MoMA. And as I've shown you, Lordship, the MoMA defines what is to be paid, defines the minimum throughput of the plant. It knew exactly what was happening, and it defines the term of the contract.
I suppose it wouldn't be able to discern the profit element.
That's neither here nor there. I mean, it's agreed that it's going to pay this amount to Global. Yeah, sure. It's up to Global how it funds its obligations.
Yes, no, but Global's claim isn't for the top line. Global's claim is for the bottom line. It's for the profit.
Yes, but
yes. So Lord Wilson is right that you couldn't read MoMA and know how profitable is that going to be to Global. I mean, Global would have to come along and prove that with these inputs it would, and its estimated outputs, there would be an annual profit of whatever the figure is.
Yes, which is what we did. Yes. But the fact that the government doesn't know what Global's costs are, it isn't a point that matters for present purposes. It just as if the plant had been built and Global started operating it, the government couldn't have turned around and said, "Oh gosh, it's turned out this has been awfully cheap for you. I don't want to pay you so much." That's neither here nor there. The government has agreed to pay this amount, which gives Global the right to make that amount less whatever it can, however low it can get its costs. And in any event, the government certainly knows there's a sort of a top line figure. It's not going to be more than $20 per 1,000 litres. And then in 24, we pick up again the point that the arbitrators had found that their decision was contrary to the expectations of the parties because there was a general understanding in the market. 24 is a reference back to paragraph 10. There was a general understanding derived from numerous cases and textbooks, assuming that damages for late delivery were the difference between the charter rate and the market rate for the period of the late delivery. And none of those authorities or textbooks suggested that there was even a theoretical possibility of damages for a loss for the entire length of the following fixture. That was a point that Lady Hale considered was key if Lord Hoffman's approach was to be adopted. One sees that at paragraph 92.
Talking about Lady Hale, Mrs. Jackson-Loomy at the end of 19 does quote Lady Hale in relation to this suggested test in the Acalias, but I think she quotes it in order to express doubts about it.
I'll explain her point.
Very well.
But at any rate, the point here is that the DBA was not entered into against a background of well-understood authority and textbook or industry expectation as to how to quantify damages for failure to deliver a prepared site. So again, this is the sorts of things that take you away from the normal rule don't apply in our case. Perhaps I could just quickly touch on something that Lord Walker says in paragraph 78. said that the diversity of opinion in the Heron 2 has another and more important significance. Other passages in the speeches show that their lordships had well in mind, but did not perhaps spell out at length, that this is not simply a question of probability, it's also a question of what the contracting parties must be taken to have had in mind, having regard to the nature and object of their business transaction. Well, the nature and object of the transaction between Global and the government was to put a wastewater treatment plant into operation at Parakeeta Bay. That's why the government engaged Global to build it, so that there would be one which was operated.
And to give Global the exclusive right to operate it if it was completed.
Yes, the exclusive right to operate it for 12 years. That one would normally expect that that would be a factor that Global would take into account in pricing the DBA.
Well, there's no finding about
There's no finding as to that, but my submission is that when one is considering the position of reasonable parties in the position of the government and Global Water, that is the assumption that the government would be making.
I don't think we could make any assumption about the pricing of the DBA. And they were paid 70% of the price. Your clients were paid 70%. Is that right?
Yes, and don't claim to have suffered any loss under the DBA.
No, but what actually happened isn't our concern here. On any view, we are assessing matters at the time of the commencement of the two contracts.
But my point, it's not the biggest point in the world, but my point is simply that if a party enters into two contracts with the same counterparty at the same time, normally you would expect a party to have in mind the income under both when it's deciding on its pricing. But I don't need to press the point. The conclusion that I invite the board to draw from the Achilles is that reinforces, those considerations reinforce the criticisms which Global makes of the award, because the only circumstance which the government points to as showing that it didn't assume responsibility under the DBA for Global's loss of MoMA profits is that the MoMA is a different contract from the DBA. That's essentially the point that the arbitrators relied on. And in my submission, it just goes nowhere. There could be all manner of explanations for the parties entering into two different contracts for the two different phases of the overall project. One's a capital contract, the other's a revenue one. They may have had different accounting treatments. The insurance needs would be different under each. One was expected to be performed within 180 days, the other over 12 years. So the first one's going to become irrelevant much sooner, you would expect. Now, there's no finding about any of this, and it doesn't matter because it's not a question of why, as a matter of fact, the parties entered into two different contracts. There's no finding about that. For the government's point to get off the ground, it would have to say that it necessarily follows from there being two contracts that liability for breach of one cannot extend to loss of profit that would have been made under the other, or that that is the obvious implication of there being two contracts. And it has to be necessity or obvious implication because what we're talking about in the Achilles is an implied limitation on liability. And the rules for the implication of terms are that you only have an implied term, as my Lord Sales says, other than the Liverpool and Irwin type, one only has this sort of implied term where it's necessary or obvious. And it's neither necessary nor obvious from the fact of two contracts that Global's loss is irrecoverable. And that is the fundamental reason, in my submission, why the award is wrong in law in relation to the DBA claim. It takes it as implicit in the fact of there being two contracts that the parties intended to restrict what losses would be recoverable for breach of each contract. But that simply doesn't follow as a matter of logic or law, and it doesn't satisfy the test for the implication of contractual terms. So briefly, I should deal with the second error that the government says appears in Global's case. It says that it's a misconception that the only plant constructed under the DBA, that only the plant constructed under the DBA could be managed under the MoMA. And this really comes back to the point that we've been on before. The short answer is, in my submission, that the award finds that the opposite is the case, because it says that performance was manifestly conditional on completion of the DBA. But in any event, the idea that there could be a plant built other than under the DBA which satisfied the MoMA depends on facts which are not to be found in the award. So that's what I was going to say about the claim under the DBA. Can I turn, therefore, to the claim for breach of the MoMA? The issue here is whether the arbitrator's failure to find an implied term is an error of law on the face of the award. There's no suggestion that if there was any relevant implied term, the government complied with it. Global submits that the Court of Appeal was correct to find that there was an implied term that the government would not prevent the occurrence of the commencement date, but wrong to find that that meant that the government was obliged to provide Global with a plant. Now, of course, if the Court of Appeal was right, the government is still liable to Global because, as the award states, no facility was built. So the government was, in fact, in breach of the implied term found by the Court of Appeal. And my submission is the award ought to be remitted in any event for that reason. But let me explain in more detail our case. Now, there's no dispute about the test for implied terms. But
I'm sorry, I'm finding it a little bit difficult to follow because you're dropping your voice.
You're dropping your voice.
I'm so sorry. I'm so sorry. I will endeavour not to do so.
Thank you very much.
Can I just briefly mention 2 points about the test for implied terms? 2 points explained by Lord Neuberger in the Marks and Spencer case. There's no need to turn it up. Implied terms of the sort in question are terms which are implied into a contract in the light of the express terms agreed by the parties, commercial common sense, and the facts known to the parties at the time the contract was made. That's paragraph 15. And the other point I wanted to draw attention to is in paragraph 21, that what one's concerned with here is the intentions of reasonable people in the position of the parties at the time they were contracting. Now, Global's case, as you'll have seen, rests on the principle identified in cases such as Mackay and Dick, CEL Group and Ned Lloyd Lines, and Secured Income Real Estate in St Martin's. And can I just very quickly trot through the relevant points there? Mackay and Dick is at tab 13 of the authorities bundle. It's a case about the delivery of some piece of equipment which had to be tested, and the buyer didn't allow it to be tested, and then resisted paying for it. The passage I rely on is at page 263.
It's the start of the second full paragraph.
Exactly, my lord. Perhaps in that case I don't need to read it out. It's in the Court of Appeal's judgment in any case. The CEL Group case is to the same effect. That's tab 7 of the bundle. Obviously a more recent decision of the Court of Appeal. Just quickly, this was a case where the claimant had the exclusive right to provide road haulage services to the defendant for 3 years, and the defendant merged with another group which had its own haulage business, and there ceased to be any discrete part of the business of the defendant, and the claimant wasn't given any exclusive right in respect of any part of the haulage business. Now, the passage that I rely on is at page 695 in the decision of Lady Justice Hale, as she then was. And it's at paragraph 15. Picking it up at the second line, everything depends upon the true construction of the contract in question. If the agreement was that CEL would have the exclusive right to provide for all the defined haulage requirements of NLL's business over the 3-year period, then there's no difficulty about implying a term or applying a rule of law that NLL would do nothing of their own motion to make it impossible for CEL to supply those requirements. Over the page at paragraph 20, she quoted from judgment of Lord Justice Donaldson in Bournemouth and Boscombe Athletic against Manchester United. A case about a footballer being paid to score goals and then not being allowed to play. Lord Justice Donaldson said, I have on occasion found it a useful test notionally to write into the contract under consideration a declaratory clause expressing the fact that the parties are not subject to the obligations which would flow from the clause which it is urged should be implied. I think it's useful in this case. We then get a contract reading, it's further agreed that Manchester United will pay a further sum of £27,000 to Bournemouth when Edward McDougall has scored 20 goals in the first team competitive football for Manchester United, provided always that Manchester United shall be under no obligation to afford McDougall any reasonable opportunity for scoring 20 goals. It at once becomes clear that the inclusion of the proviso renders this part of the contract inefficacious, futile, and absurd. We say it would make no commercial sense if the MoMA contained an express provision that the government was at liberty not to prepare a site on which Global was to build the facility, pursuant to a contract entered into on the very same day. That would turn the MoMA into an option contract, which it isn't. Secured income real estate is a decision of the High Court of Australia at tab 19, and the passage that I rely on is from the judgment of Justice Mason. At paragraph 25, he cites the passage in Mackay and Dick that I referred the board to but didn't read out. And at page 26, paragraph 26, I beg your pardon, he says this. It's not to be thought that this rule of construction is confined to the imposition of an obligation on one contracting party to cooperate in doing all that is necessary to be done for the performance by the other party of his obligations under the contract. As Chief Justice Griffith said in Butt and MacDonald, it is a general rule applicable to every contract that each party agrees by implication to do all such things as are necessary on his part to enable the other party to have the benefit of the contract. Now, the Court of Appeal accepted the principles that flow from those cases in paragraph 71 to 74 of its judgment, but the Court of Appeal considered they led to a slightly different implied term to that relied on by Global. The government says in paragraph 58 of its written case that the Court of Appeal was wrong to apply these principles at all, but as I've said, if these principles don't apply, then the government was at liberty to prevent the occurrence of the commencement date. That is just unsustainable.
But is it not open to the government to say that the implied term for which you contended before the arbitrators wasn't something as broad as we see in Mackay and Dick, but was a more specific one, focused solely on the DBA?
This is what I've called the pleading point.
Yeah, well, I mean, it is a pleading point, but the discussion in the Court of Appeal is all well and good, but did any of that discussion happen before the arbitrators? Because we are being asked to look for an error of law in the arbitrator's decision, and arguments that were not advanced before the arbitrators are not readily the basis of finding that they've made an error of law.
Well, let me say first that Mackay and Dick in all those cases were the subject of submission before the arbitrators. But I recognise that I'm making a submission that there's an error of law on the face of the award, and the arbitrators don't refer to them on the face of the award. So let me answer the point in this way. The government complains, as it has done before, below, that Global Water is changing its case from arguing that the government was obliged to prepare a site to arguing that it was implicit that the government wouldn't prevent the occurrence of the commencement date. Now, first of all, even assuming one characterises that as a change of position, the government has never identified any prejudice that has been suffered as a result of this. It's never suggested that it would have wanted to advance any different evidence or argue any other factual findings if Global's pleading had been differently phrased. But leaving that point to one side, there's nothing in this complaint. The award shows that Global argued in the arbitration that the MoMA impliedly required the government to provide a prepared site. And Global says that that is the way in which the government prevented the occurrence of the commencement date in the circumstances of this case.
So why have you altered your aspiration?
It's a more compendious way of putting the point. It doesn't really matter, frankly.
Well, it does it not? Because one could well see, if there was an argument that the government would do everything that was necessary to enable the site to be completed, to enable the plant to be built, if that was an implied term of MoMA, then you wouldn't be facing the argument which found favour with the arbitrators that the implied term for which you argued could not be implied, because they're saying that that was something which was stated in effect in the DBA, and if you'd wanted to put it in MoMA, you'd have put it in. So it seems to me it's much easier to fit a more generalised statement of the principle as an implied term in MoMA than it is to fit the particularisation which you advanced in front of the arbitrators.
Well, my Lord, what we say is that as a matter of law, there is an implied term about not preventing the occurrence of the commencement date. And the arbitrators didn't find that. It's not in the award. That, we say, is an error of law on the face of the award. What the government is trying to do is adduce material outside the award to, namely the pleadings, to justify the award. It says, well, effectively the government's saying, well, the point arises in circumstances in which it is accepted that as a matter of law there was an implied term not to prevent the occurrence of the commencement date. And in those circumstances the government says, but you can't set aside the award, you can't remit the award on that basis for that error of law, because look at these pleadings over here, that wasn't Global's case. Now, that's not a permissible course in my submission. You can't justify the award by something which is bad on its face, by something outside the award. That's just not the way it works. But if one were to undertake that exercise, if you allow the government to look at the pleadings, then you also have to let in the course of argument and all the other material that potentially comes from the course of the arbitration to see what actually happened. Now, my submission is you shouldn't let any of this in, and that's the whole point about error of law on the face of the award. You only look at the award. But if you're going to allow some of it in, then you have to allow it all in. And when one looks at the transcript, let me show the relevant passages to my lords. At page 311 of the bundle, there is a transcript put in by the government at the Court of Appeal stage of the first day of the arbitration.
Is there not an objection by Mrs. Jackman-Loomy to our looking at this?
Can't be an objection to this one because they put this into the commercial court.
Okay.
Is it agreed that we look at the material de bene essay?
Yes, so the transcripts bundle is agreed that we can look at de bene essay. I'm not in the transcript bundle yet. I'm in the material that was before the commercial court.
Okay.
So page 311. I'll come to the transcripts bundle in a minute. But page 311 is in the course of my opening remarks in the arbitration. At line 23, I said, we say that it's implicit in this agreement that the government will not do anything which prevents or impedes the commencement of operations under the MOMA. And then at page 324, there's another passage which, as you'll see, the transcript writer's got, it's clear there's one or two mistranscriptions in it, but I'll show it to the board anyway. Page 324, this is still in my opening remarks. Picking it up at line 14, the term of the MOMA couldn't start unless the government provided the prepared project, should be site, not item, and we've set out the authorities we rely on. And in support of that proposition, and in support of the proposition that where a contract is conditioned along, I think that should say conditional, on the occurrence of an event, a term will be implied to prevent the occurrence of that event. One can put it another way, that the government isn't entitled to take advantage of its own failure to provide the prepared site in order to avoid performance in the MOMA. So it's quite clear in opening I put the point in the same way. And in the transcripts bundle, this, which is agreed you can look at de bene essay, there are my closing submissions, and the relevant bit starts at page 653.
Sorry, these are closing submissions in which?
In the arbitration.
In the arbitration.
And I certainly won't read this out because it's quite a long passage, but it starts on page 653. You'll see at line 14 I turn to the issue of the implied term. And then at line 23, I refer to the CEL case, and I take the court through that. And then at page 656, line 6, that's the first case I was going to show you, gentlemen. The second one is an Australian case, and it's the secured income real estate case that I've shown to the board, and I take the arbitrators through that. The passage goes on to page 658. Those are the propositions at the top of the page, line 2. Those are the propositions of law I rely on, and all of this is entirely consistent with the test for implied terms in Belize Telecom. The arbitration, of course, took place before Marks and Spencer. Since we're there, line 13, I make a reference to the evidence. Mr. Samuel accepted, and it's in any event obvious, that Global Water, Mr. Samuel was one of the government's witnesses, accepted that Global Water couldn't begin receiving revenues if the government didn't provide a prepared site for Global Water to build on. That's
something they didn't do. What is it that they did which, to quote your submission higher up, prevents the occurrence of the event?
They failed to...
That's an omission. That's
yes,
not a...
yes,
it's not the same as the Sterling and Maitland type of condition, which is that you can't do anything to prevent the occurrence.
Well,
it's not that you have to do something.
Well, perhaps I should have given the facts of the secured income case.
Well, it's also the football case. I mean, it was the omission to put the footballer, take him off the bench and put him on the field.
Yes. In the secured income case, it was the failure to enter into a lease with the claimant. So it's not just omissions, it's positively doing things as well.
Yeah.
So there is, in my submission, absolutely no basis for saying that Global didn't rely on precisely the point of law that I rely on now before the arbitrators, and there was no objection, no pleading point taken in the arbitration about this. This is an error of law on the face of the award.
Well, except that in paragraph 15 of the award, it says that Global's entire case is there should be implied into the MoMA a term that the government promised to perform its obligation to deliver a prepared site to Global. Was that your submission?
My submission was exactly as you've seen.
But what was the implied term that you asked the arbitrators to find?
As I've said, the implied term was that it wouldn't prevent the occurrence of the commencement date. It is absolutely correct, my Lord, and I'm not trying to get away from this. It's absolutely correct. Let me show, my Lord, the pleading, because there's no, I don't want to hide from it.
Again, we're talking about error on the face of the award. Did you, on the appeal, ever say, oh, the arbitrators have got it wrong, our entire case wasn't, as stated in paragraph 15?
What I said in the Court of Appeal was there is no material difference between, and Mr. Justice Leon accepted this, there's no material difference between saying the government was obliged to provide the site and the government, there's no material difference on the facts of this case between saying the government was obliged to prepare the site and the government was obliged not to prevent the occurrence of the commencement date. So that's...
But I can see one could readily say that the term stated in paragraph 15 is a subset of the wider principle. But what I'm trying to get at is, what did you ask the arbitrators to find in the arbitration? Was it what is stated in paragraph 15?
Well,
that's at MS page 7.
Shown, Lord, what I said in the opening, which I invited the I'm not going to find this instantly, what I said in the closing, but I've...
Well, I mean, I can fully see the strength of your point that there must be a term implied into MoMA, given its nature. But what I'm trying to get at was, given the limited nature of the review which the courts can make, are we in a position to say that that the parties argued for a term different from that recorded in paragraph, or the Global argued for a term different from that recorded in paragraph 15? Because otherwise, then we are looking at an argument which wasn't advanced before the arbitrators, and I wonder if that would fit in with the jurisdiction we have to intervene if there are errors of law on the face of the award.
Lord, in my submission, it would fit in with that jurisdiction, because the the question is there an error of law on the face of the award? And the hypothesis that I'm working on, because otherwise my point falls away, is that there is an error of law because the arbitrators should have found that there was an implied term that the government would not prevent the occurrence of the commencement date. Now,
I'm not quite sure that I'm following that. If you didn't ask them to find such a term, then it wouldn't be an error by them, would it?
They would have erroneously rejected the idea. They would have failed to find an implied term which would have given Global the damages that it was entitled to. Now, if one thinks about what would have happened in the arbitration, theoretically, suppose the government had said in closing, it's not open to Global to reformulate its implied term in this way. Then the arbitrators would have had a pleading point to decide, and that would have been a matter for them. And they might have agreed or they might have disagreed. But that's a matter for the arbitrators to decide. It's not a matter for the court to decide what they ought to do about that.
I was actually on a slightly different point.
I'm sorry.
Which is, suppose, I appreciate it's a live issue factually, but suppose the only implied term that you asked the arbitrators to find implied is that recorded in paragraph 15. You didn't ask, I'm just asking you to assume on the facts, you didn't ask for the wider Mackay and Dick type implied term. And in due course, the arbitrators declined to find the narrower term and simply don't deal with the Mackay and Dick term. I'm struggling to see why that would be any error at all by the arbitrators, because they weren't asked to address such a case.
My suspicion, the way it would work is this. I would say the arbitrators have made the award, when you look at it on its own, contains an error of law, because when you look at the facts set out in the award, as a matter of law, there was an implied term. The government would then say, aha, but you didn't, if you're now going to say that, first of all, there is an error of law, therefore the award should be remitted. The government could say, no, you shouldn't remit it, because if it's remitted, I will be submitting that to the arbitrators that it's not open to Global to run that new implied term, as we're hypothesizing it is. I will be submitting to the arbitrators that it's not open to them, to Global to run that new argument because they didn't run it before. The arbitrators, the only decision that the arbitrators could reach on that question is that Global is shut out. Now, if the government could persuade the court that that's the only result that could follow if the matter was remitted to the arbitrators, then I've lost. On the hypothesis that my Lord's put it to.
Speaking for myself, I'm still struggling a little bit at the prior stage, because it seems to me to be rather contrary to the idea that everything should be disposed of, if possible, within the arbitration, with very limited grounds to go behind what the arbitrators have done. That you seem to be saying that you could keep some point of law up your sleeve, or just not think about it at the time of the arbitration. You look at the arbitration award and suddenly realise, well, here is this other very good way I could have argued my case, even though I didn't. But they haven't dealt with that. That is an error of law on the face of the record, and therefore I'm entitled to invite the court to intervene in the arbitration, and then, in effect, and I think you're saying, to apply to remit the matter.
If one looks at an award and looks at the facts set out in it, and sees that on those facts there is a legal conclusion which is not reflected in the award and which makes a difference, the award, in my submission, contains an error of law. What you do about it is stage 2. But at the starting point is there is an error of law. Now, on the facts, as it turns out, as I've shown you, Lordship, the arguments that I advance are arguments that I advance in the arbitration anyway. So, asked me, did I complain to the commercial court that the arbitrators were wrong in paragraph 15 in the way they characterised my case? I didn't, because it doesn't make any difference. It's because, as I've put it, the failure...
Even on your case, because if they had mischaracterised it, you wouldn't have had, and they should have stated that there was a wider argument asking for a broader implied term. You wouldn't have had to do with what you describe as, you wouldn't have to deal with what you described as stage 2, persuade someone that you should be allowed to raise it now.
I've argued the case the way I've argued it.
Yes,
I can't revisit that now.
No.
But I mean, strictly, if you did raise an argument which is different from that recorded in 15, wouldn't the way to have taken issue with what the arbitrators had done have been to say this is misconduct by the arbitrators because they haven't dealt with a point that we raised. And that would be the basis for going behind the arbitral award, rather than the point that I continue to struggle with, that you can not have raised a point at all, you read the arbitral award and suddenly you think, oh, there was another way I could have put my case, which I didn't. And that counts as an error of law which permits you to go behind the arbitral award.
Lord, in the circumstances of this case, since the failure to prepare the site is the manner in which the government failed to, or the manner in which the government prevented the occurrence of the commencement date, it doesn't make any difference because the way I have put the implied term in the commercial court and before your lordships is it reflects the underlying point of law rather than the particular facts of the case. I mean, if one thinks of it in this way, there will be all sorts of ways in which the government might prevent the occurrence of the commencement date. It might change its policy on sewage or something. All sorts of things that could happen. It is a slightly artificial exercise to say that the MoMA contains implied terms, one specific one for each one of those theoretical possibilities. The more sensible way, in my submission, of capturing the implied term is by reference to not preventing the occurrence of the commencement date.
Yes.
What I did in the arbitration was focus on what the breach was. And in my submission, it doesn't make any difference.
Well, I wonder about that, because what one has to fit, the implied term has to be fitted into the contract into which it is being implied. And I can see that there might be strong arguments that there should be a general statement along the Mackay and Dick line. Of course, one can't take steps to prevent or deliberately omit certain actions to prevent the contract starting. But it's quite a different matter to say this particularization of that principle is the term that should have been in the contract.
Well, there was no doubt, Lord, that the thing that Global was complaining about, the only thing the key thing that it was complaining about, and this is reflected in the award, was that the government hadn't prepared the site.
Yes.
And that, in my submission, is a breach of an implied term of the MOMA.
Well, but can it stand with the condition precedent? That's just the question. You're going to deal with the point, aren't you?
I'm not sure I've quite understood my lady's question.
Well, the parties have agreed to deal with that point by creating a condition precedent, which is not an implied term. The plant will be ready, and that the MoMA will operate from the commencement date, as defined.
Yes, and the implied term for which I contend is that the government won't prevent that occurring. Sorry, I'm sure it's me.
Well, it's just that they've taken the trouble to put a commencement date in, which is to trigger the liability, or rather the operation of the plant. And they have defined it in a particular way, as the plant being ready. They've said nothing about obligations. And this is a point made in one of the judgments. They've chosen to do it in this way.
The Mackay and Dick implied term, if I can put it that way, only ever arises in circumstances where there is a condition precedent, where there's something that has to be done before obligations are triggered.
Yes, but this is a contractual condition precedent, an express contractual condition precedent,
Yes, but
which is of a different nature, because it sets out the totality of the agreement, especially with the entire agreement clause.
The Mackay and Dick implied term only arises where there is an express term that says that obligations will follow from something happening.
That's right. It's the creation
And that's the same in this case. The the express term provides that obligations will flow from the commencement date, just as obligations flowed in Mackay and Dick from the completion of the test of the piece of equipment. And the implied term is not to prevent that. That's right.
But there's been a deliberate choice, one must assume, not to carry into MoMA the express obligations in the DBA. Now, whether it makes a difference is another matter. So there isn't an express warranty that the government will ensure that the plant is made available, the site is made available for the installation of anything of that nature, as though we see in Clause 6. So that's the argument, is that when you put them together, there's a deliberate design point in the construction of these two agreements.
So I now understand the point that my lady's putting to me. I'm sorry, I'm
no,
very
it's
slow.
Put very badly, I'm sure.
No, not at all. So the point that's being put to me is that there can't be an implied term which is an express term of a different agreement. The answer to that is that my case never depended on the government preparing the site in accordance with Clause 6.1 of the DBA. It depended on there being an implied term for the government to prepare the site. Now, as it happens, there was a term in the agreement, in the DBA, that the government had to prepare the site, but that was incidental to my case under the MOMA. My lady says, well, since there was an express term in the DBA, then it can't be a part of the implied term in the MOMA. Well, if that's right, that reinforces my argument that I'm entitled to recover damages for breach of the DBA, because if Clause 6.1 doesn't entitle me to these damages, then you have to repeat it in the MoMA, because otherwise the government is able to prevent Global from getting the profits to which it's entitled under the MOMA.
Yes, but no doubt it says that you're not entitled, and I have to try and understand the case both ways. No doubt they're saying, fine, you build the plant, and if you build it, and if it's completed, then you can have the management agreement. That's a very vernacular way of putting the two agreements point, isn't it? A very colloquial way of putting it. It's not the finesse.
I understand.
The council will put it, no.
Yes. But to continue the vernacular, on that footing, what the government is not entitled to do is to stop Global from building the plant. You can't say, you build the plant, and if you do it, you can make this money. By the way, I reserve the right to stop you building it. That's commercial nonsense.
It's keeping the footballer on the bench.
It is. Yes. It is. It is.
Do we have the memorials of the parties in the arbitration? I mean, their pleaded case.
We have Global's pleading, not the defence.
And can you just tell me where, or at some point?
No, I can. Let me tell you straight away. So let me deal with this, because there's a jurisdiction.
You're going to come to
it. No, I'll deal with it now. But there's a jurisdiction point as well, which my learned friend raises. So far we've been dealing with what I call a pleading point, a pure point of you didn't plead it, so you can't run it now. My learned friend, which has been the point that I've understood my learned friend to be running throughout this case, but in the written case she also has a related jurisdiction point. So and in relation to jurisdiction, I entirely accept that jurisdiction of the arbitrators is a matter for the court, of course. The jurisdiction of the arbitrators flows from the reference, from the arbitration agreement and the reference to them. The arbitration agreement isn't particularly enlightening in this case, but I'll just show it to you. It's in the MOMA, it's at page 535, clause 14. 14.1, in the event of a dispute, the parties will use reasonable efforts to settle it through negotiations. And then 14.2, the parties shall each appoint an arbitrator, and the two arbitrators so appointed shall in turn select an umpire. Such arbitration shall be governed by and shall be in accordance with the arbitration ordinance. So, as I say, not particularly illuminating, but I should show it to you. Then what happened was that Global referred its claim to arbitration pursuant by notice, and that notice is at page 489. There was one under the MOMA and one under the DBA. This is the MOMA one. And the key part is over the page at paragraph 2. The company hereby gives notice to the government to appoint its arbitrator pursuant to clause 14 of the MOMA in respect of all disputes between the parties which concern, relate to, arise from, or are in any way connected with A, the government's express and implied obligations under the MOMA, B, the government's failure to perform the said obligations, and or C, the matters referred to in this notice. And 3, the matters set out further below are not intended to and do not limit in any way the scope or effect of paragraph 2 or the jurisdiction of the arbitrator so appointed. So, in my submission, it's clear that the arbitrator had jurisdiction to deal with any form of implied term. And then what happened was, paragraph 6, the prepared cite and other matters required to be provided by the government under clause 6 of the DBA are necessary for the installation of the facility and its operation. And then 7, it's an express and or implied term of the management agreement that the government should, in accordance with the DBA, provide a prepared site for the facility.
Well, there we are.
And
that's it, isn't it, Mr. Scott?
Well, but and then just to, so because my learned friend will want me to show you this, and Lord Sales has asked me to show you it, so let me show you the
Lord
point.
Wilson's point is directed to the prior argument, that if we're looking to see what is the implied term that you were seeking, paragraph 7 gives it to us.
So there are 2 points here. There's a jurisdiction point, and I say that there isn't a jurisdiction point to be taken against me because the arbitrators had jurisdiction to find any implied term.
Yeah.
And then there's a pleading point,
Yes.
which is the one that we've been around the houses on for some time.
Yes, well, I don't want to take you back to it, but I think Lord Wilson's interjection related to the pleading point.
Yes,
It did.
And I understood it as such.
Okay.
And does the pleading point move beyond this, or in effect, is that the pleading?
That's effectively the pleading point. So, I'm not sure I can take the debate any further.
No.
It may well be, in the light of all of that, that I don't need to say anything about the Court of Appeal's formulation, that the Mackay and Dick term, as it were, translates into an obligation to provide the plant rather than an obligation to provide the site. We say that can't be right because that's inconsistent with the DBA. The DBA provides that global is to provide the plant to the government. You can't have an obligation the other way round in a contract entered into at the same time. That would, once the parties have allocated responsibility for something to one party, they can't implicitly have allocated it to the other.
Yes, I see the force of that.
So I can perhaps go over that. I have other points on this, but that will do, I think. I haven't addressed the topic of whether the transcripts in the transcript bundle, the ones that deal with my closing submissions, are admissible at all. Not in any detail. So let me just say a very quick word about that because I'm aware of the time. Now, they are not incorporated in the award. That's the first point. So they're not admissible either to show that the award contains an error of law or to justify it on other grounds. I accept that. Similarly, the pleadings are not incorporated into the award, and so my learned friend can't rely on those. On the question of jurisdiction, they are admissible, if they're relevant. Although, actually, I say the question of jurisdiction is answered by the notice appointing the arbitrators, and if it wasn't answered by that, then the transcripts would be relevant to show that the government didn't object to the Mackay and Dick type point being taken. And so if there was a jurisdictional problem, they'd waived it. As I understand it, the only reason that my learned friend resists me referring to the transcripts of the closing submissions, as opposed to the opening submissions, which have always been before the court, is that Global said earlier on that transcripts weren't relevant. Now, the context in which that was said was, first of all, the government said, you can't mount an appeal at all unless you put the entire record before the commercial court. And the response was, that's just not right, and since the transcripts aren't relevant to anything, why would we put it before the commercial court? What then happened was that the government put in 1 day's transcript because it wanted to make the point that the arbitrators should have found that there was no quantum in any event, which hasn't gone anywhere in the event, but that's what it said in the commercial court and hasn't been pursued subsequently. The point to which the transcripts are now relevant, if they're relevant at all, is a different point, and that point only arose in the commercial court after I had finished my oral submissions. Right, there was a break between the two parties' oral submissions, and in that break, the learned friend served another witness statement exhibiting the pleadings, saying, you didn't, well, first of all, you didn't say why, you just served them, and we didn't know why until it came to their oral submissions when this pleading point was taken. So, and in my reply, which was again done a little bit later, and done in writing, and if you want to look it up, it's at page 253, we complained that we hadn't had a chance to answer this point by producing other transcripts. So this is all a bit of nonsensical procedural posturing. If they're relevant, there's no suggestion that the learned friend can't deal with them. My submission, they should be in if they're going to be considered at all. I think I've overrun by 2 minutes. But,
Could I just draw your attention, just to make sure that I've understood it correctly, to page 496. This is in the point of claim, I think, in the arbitration.
Yes.
One picks it up from page 493 and back on the pleading point. And it seemed to me that paragraph 17
yes.
Very much reflects the notice of appointing the arbitrators. But this is the formal pleading in the arbitration.
Yes, my lord. And that's why I said that it doesn't take it.
It doesn't take it further, right?
Yeah.
Thank you.
But my lord's asked me where the pleading was, and that is it. And
Yes.
that is the paragraph that the learned friend relies on. So unless I can assist the board with anything else.
No, Mr. Strong, thank you very much. Mr. Hamundami.
So, my lords, we start our oral presentation at the same place that our written case started, and that is emphasizing the point that courts strive to uphold arbitration awards. And I just want to make it very clear that it's not that the government is saying that awards should be deemed sacrosanct, but certainly that the court should accord a measure of deference when dealing with arbitration awards, when entertaining a challenge to an arbitration award. There's a passage in the case of Zamalt Holdings SA and New Life Upholstery Repairs Limited. It's quoted at our written case.
doesn't amplify, actually, does it, then? These don't amplify, do they?
No.
She thought they did.
No, this simply records what you're saying. It doesn't amplify it to us, just to let you know.
So you need to keep your voice up so that we can hear very
That
clearly.
is a problem I've never had before.
It is very common. It's very common for people to be
Yes, please,
misled
my
to
lord.
think
Because
that
I'm
everything-
hearing myself through the mic, so I'm assuming that that's the sound system.
Yes.
Yes. Grateful, please, my lord.
Thank you.
So, my lords,
You're referring to a case.
yes, please, my lords. I was saying that in our written case, we referred to the case of Zumalt Holdings and New Life Upholstery Repairs Limited. There's no need for me to take you to the passage itself because the relevant passage is actually quoted in our written case, but just for the record to indicate that it's at page 1348, that's 1348 of the electronic bundle. And then I want to emphasize that in Edwards and Bairstow, and that case could be found at tab 11 of the authorities bundle, the same point was emphasized by the House of Lords in that case. And if I could take you first to the dicta of Viscount Simons, and that is at page 29. And the electronic bundle reference is 1073. And if you look just about halfway down the page, it's a sentence that starts, "It is for this reason that I thought it right to set out the whole of the facts as they were found by the commissioners in this case. For, having set them out and having read and reread them with every desire to support the determination, if it can be reasonably supported, I find myself quite unable to do so." And similar sentiments, and when I say similar sentiments, I mean in relation to the attempt or the desire to uphold the arbitration award as long as it can be. Lord Ratcliffe's dicta at page 38 of that same decision, and that is at page 1082 of the bundle. And it's to the bottom of that page. And it starts, "The reason is simply that by the system that has been set up, the commissioners are the first tribunal to try an appeal, and in the interest of the efficient administration of justice, their decisions can only be upset on appeal if they have been positively wrong in law. The court is not a second opinion where there is a reasonable ground for the first." And so this is the backdrop against which we invite the board to consider this appeal. Because it is our position that this appeal, the challenge to an award on a whole actually, is an attempt on Global's part to escape what turned out to be imprudent pleadings or imprudent contract dealings. And to support that view, the view or the submission that Global made, and it was made here this morning, orally by my learned friend, but certainly it featured in the written submissions in the courts below as well. Global has constantly been agitating for the court to find an error of law, one or two errors of law in the award, for the sole purpose that by failing to do so, they would be denied compensation. And I just want to take the board to those passages in the submissions that I referred to. So in Global's skeleton submissions in the commercial court, and those submissions start at page 204 of the electronic bundle. And those are the submissions filed on the 16th of January 2015. And I would start with paragraph 6 of those submissions. "It is respectfully submitted that the arbitrators were wrong on one or both of these matters. The effect of their award is that, notwithstanding that Global had a contractual right to profit from operating the facility for 12 years, the government was free to abandon the project at any time prior to completion of the facility without compensating for the loss of 12 years of income under the MOME. It is respectfully submitted that the result is wrong as a matter of law, and this appeal should accordingly be allowed. Similarly, at paragraphs 16 to 19, and that is, it starts at page 207 of the bundle. It is submitted that the arbitrators erred in law because the parties should not be treated as having intended that Global would be without a remedy in those circumstances. And we will come to demonstrate, my lords, that the reason Global is without a remedy is because it misconstrued the nature of the contractual dealings between the parties and or the way it approached the arbitration, the way it approached the arbitration claim, the way it proceeded to terminate the MOME, the way it pleaded its case before the arbitration. So in other words, Global was the author of its own demise. But nonetheless, picking back up at paragraph 16, the parties cannot have intended both that profits that would have been made from performing the MOME could not be claimed as damages for breach of the DBA, and that the MOME permitted the government to prevent its performance by not providing a prepared site. The DBA was expected to be performed in 180 days, while the term of the MOME was 12 years. It is obvious that an important reason for Global entering into the DBA was to get 12 years of income under the MOME once the facility was built. It would make no commercial sense for the government to be permitted to act in a way which would inevitably deprive Global of the opportunity of earning the profits to which it was entitled under the MOME. The arbitrators found that the government did so act in breach of an express term of the DBA. The correct conclusion as a matter of law is that Global can claim such profits as damages for breach of the DBA or as damages for breach of an implied term of the MOME, whose performance government prevented or under both heads. It cannot be correct that such damages are not recoverable at all as a matter of law. Each head of claim is considered in turn below. Global submits that it is correct on both, but if it is wrong on either, that it would mean that it must be correct on the other. And that is the crucial statement with which we take issue with. Now, of course, the rest of it I had to read to the board for context, but the idea that simply because you would be out of damages means that the board or the arbitrators ought to have found you right on one point or the other is a misconstruction, please, my lords. And that is the point I want to emphasize. And then again at paragraph 36B, and this is on page 213, and that's 213. Further, if as the arbitrators found but Global disputes, Global is not entitled to claim the profits it would have made under the MOME as damages for breach of an express term of the DBA, that makes it all the more essential to imply into the MOME an obligation to provide a prepared site. The effect of the arbitrator's award is that profits are irrecoverable, which at the time of contracting, the parties anticipated Global would make, and which the government's breach of contract has prevented it from making. It is impossible to see why the parties would have intended that Global's foreseeable loss should fall down a black hole in that way. And again, just to emphasize that it's not that the loss falls down a black hole based on the contracts themselves, it's based on Global's interpretation of the contracts and the way Global's approached its claim. And I expect that to be clear as I go through my submissions. And I don't think it's necessary to take the board directly to the submissions, the other submissions filed before the High Court or the Court of Appeal, because they are words to the same effect. But I would just indicate that I would direct the board to the reply submissions of the applicant, which was filed on the 15th of May 2015. So this is Global's submissions in reply, and they were filed on the 15th of May, and they start at electronic bundle page 240, and the relevant passage is at paragraph 28. And also the Court of Appeals skeleton, and this is the skeleton that Global filed in the Court of Appeal. It was filed on the 6th of September 2016, and the the electronic bundle page is 154, and the relevant passages are at paragraphs 9, 10, and 56. And as I said, my lords, it's essentially...
What was the MS number for the second document to which you referred?
The submission starts at page 240, please, my lord.
I've got that, 28.
Paragraph 28 is at 151, is it? 251.
251. I
Yes.
got that one, but what was the next one?
It
I'm
starts
so
at
sorry,
page
Mrs.
154.
Jackman.
Yes, please, my lord. It's the Court of Appeal, skeleton.
Yes.
It's filed on the 6th of September 2016, and it starts at page 154.
Thank you.
And the relevant paragraphs are 9, 10, and 56. And my lord, the submission that we're making is that it's not for the board to improve upon the parties' contract under the guise of interpretation. It certainly wouldn't be for the arbitrators, and it's not for the board to seek to do that, well, under the guise of a challenge to an award. And certainly in the case of Wood and Capita, and this is a 2017 UK Supreme Court decision, and it is at tab 25 of the authorities bundle. And at paragraph 11 of that decision, which is on page 1339, and paragraph 11 around G. The Supreme Court held that the courts must be alive to the possibility that one side may have agreed to something which with hindsight did not serve his interest. And similarly at paragraph 41, from Capita's standpoint, the SPA, which is sale and purchase agreement, may have become a poor bargain, as it appears that it did not notify the sellers of a warranty claim within 2 years of completion, but it is not the function of the court to improve their bargain. So to set the tone for the rest of our submissions, we would say that the court should refuse a meticulous analysis of the award, which Global, we submit, is seeking to do simply to rectify imprudent contractual dealings or its imprudent approach to the arbitration, because doing so would negative the objectives of arbitration, the savings in time and costs, and the finality that is expected of arbitral awards. And in terms of the time, certainly the references to arbitration were lodged on the 12th of June 2013. It has now been some 7 years. So certainly that is very evident. So moving on, please, my lords. I don't think it's necessary to rehash the facts of this particular matter, but there are 2 points I would like to make briefly. And the first is that based on paragraph 32 of the award, and that is at page 13 of the electronic bundle, but it is a passage that my learned friend referred to previously, and it's the passage where the arbitrators indicate that there was no claim made by reference to damages or profits calculated by reference to the DBA. So we emphasize that point to make the submission that Global could be taken to have received everything to which it was entitled, calculated by reference to that contract. So it's not a case where Global could complain that it has been completely out of pocket despite the breach of the DBA. That's the point I would like to make. And so it brings me to the second point, that the regret expressed by the Court of Appeal, because the Court of Appeal in its judgment did say that it is with some regret that it doesn't provide Global with the compensation that it seeks by reference to the MOME. But again, as I will demonstrate as I go through the submissions, this is based on the interpretation of what we submit is the inaccurate interpretation of the contract and or the improper approach to the pleadings in the arbitration. In terms of the relevant legal principles where an error of law is concerned, it is set out. In our case, I don't propose to take the board back through it. We submit that, just summarizing, we submit that there's a tripartite approach that could be gleaned from the case of National Housing Trust, and that's a 2015 Privy Council decision of Lord Neuberger. And this is at paragraphs 7 and 8 of our case before the board, and it's MS page 875 and 876. And simply speaking, we are proposing that the court is called upon to identify the alleged error.
This is the approach to alleged error of law on the face of the award. It's setting out how the court should go about addressing a challenge of this nature. Yeah.
Indeed, please, my lord.
Yes, this is the foot of paragraph 8 in your case, the 3 points.
Yes, please, my lord. Yes,
Thank you.
please. So, my lord, I don't need to take the board back through it, but in terms of the error of law, there are 2 points that I want to make. Now, the definition of what constitutes an error of law we deal with at paragraph 9 of our case, and it's the classic definition from the case of Edwards and Bairstow, that where it was held that it must be shown that the arbitrator either misdirected himself in law or that the decision was one that no reasonable arbitrator could arrive at. And that is the dicta coming from Lord Radcliffe at page 36 of Edwards and Bairstow, which is MS page 1080 for reference. Now, this passage was adopted as correct by Lord Diplock in the case of Photo Production Limited and Pioneer Shipping Limited and BTP Dioxide Limited, the NEMA, which could be found at tab 18 of the authorities bundle. MS page 1184 is the start of the decision. At page 1202, this is MS page 1202, it's page 742 if you're looking at the reference numbers for the case itself. And it's around letter B.
Letter?
B.
Thank you.
Under the substituted procedure for challenging an arbitrator's award, which is provided by Section 1, an appeal to the High Court on any question of law arising out of an award is given in terms which expressly confine the appeal to questions of law. And ever since the decision of this House 25 years ago in Edwards and Bairstow have been understood, at least where the tribunal from which such appeal lies is not itself a court of law, as bearing the precise meaning as to the function of the court to which an appeal on a question of law is brought, that is stated in the classic passage to be found in the speech of Lord Radcliffe, and then the classic passage goes on. And I wouldn't trouble my lords to actually go to the passage because I'm sure that it is well known. But the important part of Lord Diplock's decision, for my purposes currently, is on MS page 1204, and again around letter B. And it starts, whether a particular event or series of events have made further performance something radically different from that which was undertaken by the contract, involves, as is indicated by Lord Radcliffe's adverb and its off-use variant, fundamentally, a question of degree, upon which, though faced with the same facts, different opinions may not unreasonably be held by different men. And my lord, it's a common sense submission, but I just found it interesting that Lord Diplock himself said it. Because of course, the very nature and the very beauty of the profession to which we all belong is that two persons could look at the same passage, look at the same statute, look at the same section, the same section in a statute or the same passage in a decision, and come to completely polarized interpretations as to what it would mean.
But in this passage, forgive me, I'm sorry, I didn't mean to interrupt you. But in this passage, the court is Lord Diplock is addressing the concept of frustration.
Yes, please, my lord. Which
is an area where there may be scope for different views in the application of the law to particular facts.
Understood, my lord, and that's what I'm saying. The submission I'm making is a common sense one. I'm just referring to the words of Lord Diplock in this respect, but I understand that frustration involves a question of degree. But yeah. I'm saying even if I was to step outside of the decision, this particular decision, my submission would still be that there are circumstances where, although persons argue or adopt a position that are completely polarized, within that spectrum, although they exist at polar ends of that spectrum, they can both be deemed reasonable. That's the point that I'm making. So that where the mere fact that you disagree with an argument, a submission, it doesn't necessarily mean that it's an unreasonable one. And that in a challenge to an award, the award should only be disturbed if the award is deemed to be unreasonable, not simply that you would have come to a different decision. So there isn't that same level of latitude as there would be in an appeal from a normal decision in the normal way. That's really the point that I'm trying to make. So even without reference to Lord Diplock's statement in the NEMA, I would still make the submission that there is a scope for disagreeing with a position, disagreeing with a decision, disagreeing with a submission, and still being able to see that the said submission, position, decision is a reasonable or perfectly rational one.
It may depend, of course, on the nature of the legal issue that's being addressed.
Indeed, please, my lord, I accept that. So, my lord, my lords and my lady, I'm conscious of the time. I do have 5 minutes. I don't know if...
Well, if you want to press on, then press on for the 5 minutes, and we'll take the short adjournment at 1, if that's in order.
Yes, grateful, please, my lord.
Thank you.
So, my lord, now I come to start treating with the actual issues raised in this claim, and I would actually start my discussion with the implied term which was proposed in respect of the MoMA, the M-O-M-A.
Thank you.
Of course, my lord, the legal principles are not in issue, so I wouldn't go through the relevant authorities on that. I would emphasize, though, the notional test put forward in the CEL case that, well, it is the CEL case that referred to Bournemouth, but the same authority that dealt with the contract for the footballer but not allowing him to play. Yes. So, and my lord, I just want you to keep that in the back of your minds, but I would in fact come back to that particular notional test later on. So in terms of our treatment of the proposed term to be implied into the MOMA, we have always complained that the said term took on a protean character in these proceedings, that as the proceedings went on, there was a change in the position. So in the arbitration, it was a question of the DBA obligations or a prepared site. Before the Eastern Caribbean Supreme Court, it was not preventing the commencement date. And sure enough, it was said to include the failure to provide a prepared site. But the very use of that word, include, is part of the problem. And then before the board, there was a shift in position as well. So if I may take the court to the pleadings before the Eastern Caribbean Supreme Court, and they were contained in the grounds of appeal, and that is at MS page 194. Paragraph 18b. Further, or alternatively, contrary to paragraph 2 of the award, there was an implied term of the MOMA that the government would not prevent the occurrence of the commencement date of the MOMA, including by failure to deliver a prepared site to Global on which to build the facility and preventing the building of the facility. And these are the grounds of appeal dated the 11th of September 2014. And similarly, at page 191, paragraph 31b, it's a similar passage, please, my lords and my lady.
And what is the document?
At page 191, it's the points of claim, and they were filed on the 16th of January 2015.
But that's the point of claim in the High Court, is that right?
Yes, please, my lord.
And you're looking at paragraph 31.
31b, please, my lord.
again, including.
Yes, please, my
So,
lord.
so you say that there was a particularised claim before the arbitrators, and then an attempt to broaden out
Yes, please, my lord.
what the implied term was.
Yes, please, my lord. And certainly, as I come to it later on in my submission, you would see that that attempt was one, or the invitation to broaden the term was one that was very much taken up by the Honourable Judge in the Commercial Court, Justice Leon. Because throughout his decision, there's reference to the provision of a treatment plant, not the prepared site that would lead to the provision of the DBA facility, which is a very specific, which is a more specific term than the term that he was willing and prepared to find should have been implied into the MOME. And my lord, there are 4 issues that we take with this particular, well, with the wider formulation, which is what I would deal with after the break.
That's a convenient moment. Well, thank you very much, Mr. Jackson. We will resume again at 2 o'clock.